Schaefer, good morning.
Good morning.
Are you here with Mr. Landers?
I am. We're
On
both
the record
appearing
in the
by Zoom
matter-
from different locations.
Thank you. We're on the record in the matter of the people of the state of Michigan versus John Mark Landers. I have file number 22-03278. Parties present via Zoom. This is the date set for a sentencing, but I also have a PA 53 violation. It looks like Mr. Landers was arraigned on the PA 53 violation back on the 30th by the magistrate and stood mute. Mr. Schaefer, how does your client want to proceed on that?
He'll plead guilty.
Mr. Landers, is that correct?
That is correct, Your Honor.
Okay, you understand, sir, that you have the right to have a contested hearing on the alleged bond violation?
Yes, I do understand.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do swear, Your Honor.
Thank you. You can put your hand down. Mr. Landers, by giving up your right to contested hearing, that means that you understand, sir, that you can be sentenced for contempt of court for violating the court order. You understand that?
Yes, Your Honor.
Okay, you understand that the maximum penalty for contempt is 93 days in jail and or up to $7,500 in fines?
I do understand.
Okay, you still wish to waive your rights today?
Yes.
Okay, anybody threatening you to get you to waive your right to your contested hearing as to the bond violation?
No.
Okay, any promises being made to you?
No.
Are you pleading guilty to the violation because you believe you're guilty?
Yes.
The violation alleges that on January 29, 2023 at 5:32, that you allegedly violated the terms of your bond conditions, which stated that you're not to harass, assault, intimidate, beat, molest, wound, or threaten the protected party. As to that violation, how do you plead, sir?
I plead guilty.
Okay, what did you do to make you guilty of that violation?
I was invited to return to the apartment with the victim, Angel Riley. The invitation was made to myself as well as my parents. I accepted that invitation and I did have contact with Angel Riley.
Okay, so you had contact, which was not allowed unless it was for the purpose of childcare, correct?
Yes.
Okay, and you didn't do anything though to assault, harass, intimidate, beat, wound, or molest or threaten her, did you?
No, Your Honor.
Okay,
Your Honor, if I may,
yes,
there is another charge pending of domestic violence.
same victim?
Same victim, same circumstance. And this would be at the same date and time as this bond violation.
Gotcha. Okay. Is that true? I need the prosecutor to let me know if Mr. Landers has a pending charge for the same date and time as this alleged bond violation that was scheduled for today.
Right, I can take a look at that to look in our filing cabinet to find out, but I don't have anything. Ready for your knowledge. Rachel. What is the date of the incident?
January 29th.
It's like on or about January 29th, we do have a domestic violence count that has been open. Let's see if it's actually signed. As it looks like it was approved by prosecutor Kristen.
Okay. Okay, thank you. Okay. So for the purpose of clarification of the record, Mr. Landers is pleading guilty to having contact only in direct violation of the bond conditions, correct, Mr. Landers?
Yes.
Okay. You're satisfied with the factual basis? I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Today was the date set for the sentencing and the underlying matter, which was domestic violence. I have a pre-sentence report. Mr. Schaefer, did you get a copy of that report?
Yes.
Any need to make changes, updates, corrections, deletions of any type?
I think the report predated the new offense, so that's missing, and the recommendation wouldn't have taken that into consideration.
Okay, you can proceed with allocution.
Thank you, Your Honor. So we are appearing by Zoom from separate locations. I think you can see my parents, or my parents, John's parents in the background at his Zoom location. John, Your Honor, I want to make sure you have the correct address because he changed addresses. It's his address, current address is 187 Cascade Boulevard, apartment 502, Lansing, 48912. And he also changed his phone number, and that's 331-401-4541.
Can you repeat the phone number, please?
331-01-4541.
The same number keeps going out. One more time.
Okay, 331-401-4541.
Thank you. Okay, any other allocution?
Thank you. So John's 21 years old. He has no prior convictions. He is a student at MSU. He's a junior. He majors in computer science. He also works part-time at Meyer in Okemos in the deli department, working about 23 hours a week. The victim is Angel Riley. And she has, since this last event, she has abandoned the party's residence, and John has moved back in on my advice. I notified the court of that. I've tried to call her, text her, email her with no response. My purpose was to see if she had intended, it really did abandon the residence, if she intended to come back, which would be fine, and I'd tell John to move out. But she hasn't responded to that. We believe she has moved to California and is living with relatives The parties have one child, Chloe. She's about a year and a half. Angel took her with her when she left the state. And a relative of Angel's has arranged for John to have FaceTime or Zoom contact with the child and has offered to allow John to visit with the child, if permitted by the court, at a city in California other than where Angel is currently residing. The bond violation, there was a no contact order. After the first arrest, Angel had contacted me indicating that she wanted the no contact order lifted. And I believe, if I recall correctly, at the time of the plea, I had indicated that to the court. The prosecutor confirmed that he had talked to her, and she said the same thing. The court had indicated, since Angel wasn't there, indicated that Angel should contact the assistant prosecutor, and either there'd be a conference or a hearing with the court to address that issue. But she never followed up on it, so that never occurred. Angel invited John to return to the home. Unfortunately, he did so. This bond violation and the new charge were similar facts, almost exactly the same facts as the original charge. Angel was very jealous. She had believed that John had had an affair. She would accuse John, then grab his phone to try to look at his text. John would grab it back. That would go back and forth, and that escalated. And in both of those events, that resulted in charges. So, I think, John, he's 21. I think he's young, he's naive. His intent was to both reunite with April and to be with his son. I think it's obvious to any neutral third party that they would have accurately predicted the outcome if he had returned, to live with her, and that's exactly what happened. This is a plea with a request for treatment under 769-4A. I'm not sure what's going to happen to the second charge. It seems that April has moved. I doubt that she's going to be returning on that charge, but I haven't had a chance to discuss that with the prosecutor yet. But we would appreciate, in this case, if the court would grant him status under 769-4A. I know that's a stretch in light of the bond violation and the new allegation. We would appreciate that to grant probation. We'd also appreciate if the court would consider not ordering any upfront jail. If the court believes the jail is required, we would request consideration to allow him to serve that on weekends so that he can continue to attend school and employment. And since April is no longer in the state, I don't think that's an issue. John has not tried to contact Angel, and she has not tried to contact him, but he has been contacted by members of her family with respect to trying to arrange some contact with Chloe, their daughter. If April does permit him to have in-person visitation with Chloe in California, we would ask the court to kindly consider to permit him to travel there for that purpose. If that were to occur, it's my understanding that it would occur in a different city than where Angel resides. Thank you, Your Honor.
Thank you. Did Mr. Landers want to make his own statement?
No, Your Honor.
Okay. You had an opportunity to review the pre-sentence report and the recommendation, as well as review your prior criminal history, which this is the only thing that's noted there. And I realized you're relatively young, but You're 21 years old. You're an adult. You have a child. We're in a situation here where you're here for sentencing on a domestic violence. You're requesting the court to give you special status, but then you violate the terms of your bond conditions. So you're essentially showing the court that you don't really consider or take seriously the court orders as it relates to what you should and shouldn't be doing while you're under supervision of the court. And then I learned that there's a new pending DV, same victim, almost identical circumstances. That's troubling. And it doesn't seem like you're putting yourself in a position to be successful if granted special status under 769.4A. I don't know what's going to happen in the new pending charge. I've not seen any reports or anything of that nature, but your attorney spoke a lot about Angel's actions. We're here to talk about your actions, not hers. And I don't care if she accused or suspected you to be cheating and she yelled and screamed and fussed and threw a tantrum. That doesn't give you any right to react the way that you reacted. You're in control of John Landers. You're not in control of her. And if you find yourself in a situation where you feel you're getting that frustrated or that your safety is at risk, it's your responsibility as an adult and a father to take and remove yourself from that situation before it escalates to a place of violence. So I think it's beneficial for you to do a term of probation because it sounds like you could benefit from some programming and to establish better structure and self-control. I'm going to give you an opportunity to do that. I'm going to adopt the recommendation of probation. You're going to be sentenced to 12 months probation. I am going to order that you spend 93 days in Ingham County Jail. Credit for 0. I'll suspend the 93 days upon successful completion of the 12 months of probation. While on probation, there's a $30 per month oversight fee that you're responsible for. I will grant the request for sentencing under 769.4A. I'm going to continue the no contact order with the victim, Angel Riley. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or controlled substance unless you have a valid prescription. Do you understand each of the conditions so far, or do you have any questions?
I understand, Your Honor.
Okay. You're going to be required to submit to random preliminary breath test and/or urinalysis. You have to pay the fee for that, okay?
Yes.
You're not to be at any bars or any nightclubs while you're on probation. Do you understand that?
Yes, I do, Your Honor.
Are you enrolled in school full-time or part-time?
I'm a full-time student.
And you're working part-time?
Yes.
Okay, I'm going to order that you maintain your student status during the pendency of probation as well as employment. I'm going to order that you attend anger management, some domestic abuse counseling, and any other treatment as recommended by probation. Do you have any questions so far?
No questions, Your Honor.
Okay, as to fines and costs, there's a $75 crime victim rights fee that you will be assessed, plus the $50 state minimum cost. that you will also be assessed. 12 months of probation at $30 per month will amount to $360. I'm going to assess a fine of $500 for the bond violation. We'll have 12 months to make payments on that, okay?
Okay.
So total of $985. And again, you'll be making monthly payments on that. So over 12 months. You'll be paying about $82 a month. Lastly, there's an advice of rights for probation. It says you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs, except for the cases of domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge. You have the following rights. You have the right to request early discharge from probation once you completed half the original probation term ordered by the judge. Your probation officer may, but is not required to, file with the judge a request for early discharge. The probation officer must send to you and to the prosecuting attorney a copy of that request. Prosecuting attorney has 14 days from receipt of that request to respond. If a hearing is scheduled, you have the right to retain an attorney. You do not have a right to hire an attorney for any hearing for early discharge. You are on probation for domestic violence, so you would not be eligible to make such a request. Do you understand that?
Understood, Your Honor.
Do you have any questions about your fines and costs?
I do not.
Okay. Any additional matters for the record today, counsel?
No, thank you very much, Your Honor.
You're all set, sir.
Okay.
Korupski, is Carmen Korupski here?
John, you can leave the Zoom.
Who's representing Mr. Easley? Does he have an attorney?
I don't think so.
It doesn't say anything here. Mr. Easley, did you request court-appointed counsel?
For court counsel?
Yeah, did you request the public defender?
Yes, ma'am.
Do we know if he was approved or denied? Do me a favor. It looks like on the 14th, it said he was denied. It says when asked if he wanted to reapply, he said no. You were denied at your last court date, sir, and then you stated you did not want to reapply for court-appointed counsel. So who are you going to get to represent you, sir?
I'm so sorry. This was the incident September 27th.
Let me double check. Why, do you know why they have you in a dark room?
I do not.
Is in jail. Let's see here, date of incident, allegedly, September 16th. We find out why. What are you gonna do for an attorney, sir? You're being charged with one count of assault with a dangerous weapon. That's a felony, maximum penalty 4 years and or $2,000. Did you want to reapply for court-appointed counsel?
Yes, please.
Okay, we'll get you in a meeting room with someone when we get a chance. Who are you here for? Is it Mr. Pomerlee?
For Rubsky.
Oh, I just issued a bench warrant.
Okay. No, she's not here.
Okay, sounds good. You think you can log in and help this
Yes, ma'am.
person? Thank you. Let's reset his PCC.
I'm his mother. I'm not able to help represent him.
Are you an attorney?
No, I can't help him like walk him through and like try to because I'm the person that makes him
Right, yeah.
I'm the one who's supposed to resolve it.
Okay, well, this is a public defender that's gonna log in and try to help him refile an application. So if you wanna talk to him, that's fine, okay? And then you obviously can talk to the prosecutor, okay? March 9th for new PCC at 9:30. Sounds good. Have you already spoken to the prosecutor, ma'am? Okay, did you want to speak to the prosecutor?
Sure.
This is his mom, Mr. Easley's mom.
Oh, very good.
Yes, hi.
Let's not speak in here though.
What's that?
Oh.
Okay, who's ready to run? Mr. Cartwright, you have somebody waiting.
Yes, we are.
We're on the record in the matter of the people of the state of Michigan versus Richard Lee Nostrand, file number 23-00390, council appearance.
Steve Wazik, appearing on behalf of the people of the state of Michigan. Thank you, Your Honor. My understanding is to my right.
Thank you. How are you, Mr. Nostrand? I'm doing very well. Today is the date and time set for a preliminary examination. 1 second. Mr. Easley, let's get you in a private meeting room, and as soon as Mr. Palmer logs in, we'll put him in there, okay? Can you hear us, Mr. Easley?
Yes, Ms. Judge.
Okay, very good. I'm gonna put you in there now. It's motion light scratching. Okay. Okay, I have one count of carrying, weapons carrying concealed. My understanding is that you want to make an unconditional waiver to the circuit court. Is that correct? That people are waiving their exam?
That's correct, Your Honor.
That's a correct statement, Your Honor.
Thank you. Is there an offer?
At this point, there's no offer. Negotiations will continue in the circuit court.
Okay, Mr. Nostrand, do you understand that you have the right by statute to have a preliminary examination here in the district court on this matter?
Yes, ma'am.
You understand that the purpose of the examination is to require the prosecution to bring forth sufficient evidence to establish that there's probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am.
You wish to unconditionally waive your examination?
Yes, ma'am.
You understand that once you waive it, you can't change your mind.
Yes, ma'am.
And this matter will be bound over to the circuit court. You recognize that?
Yes, ma'am.
Anybody threatening you to get you to waive your exam?
No.
Was there any promises made to you in exchange for you waiving your exam?
No.
You're waiving it freely and voluntarily.
Yes, ma'am.
Hey, find over date's gonna be March 8th, 2023. You do not need to appear in court on that date. That's the date they get the file from the district court. Your next court date will be in circuit court, but it'll be a pretrial, okay? You and your attorney will be made aware of that. Do you have any questions at this time?
No, right?
Calling is set at 500 Crystal Cognizance that will continue. Any additional matters for the record?
Nothing's been the people, thank you.
No, Your Honor.
Thank you.
Thank you.
Oh, tell him I have a question.
Yes, that was the terror.
Okay, well, we have next, Mr. Commerce, Edwards, he didn't appear. Raphael White is gonna run,
I feel like Mr. Cartwright, we just went up to speak with him.
okay.
Yes, we
Grant
move on.
Demine is gonna run,
I'm sorry?
Mr. Demine,
According to Ms. Murphy.
Yes, that's my case, Judge. It will be running.
okay, sounds good. And then Tyler Hatton is a plea.
That is correct.
Yep.
I guess we can do that.
Patton.
Hatton, or Hatton, yeah.
And Yeah, I didn't, I 10 o'clock last night.
Correct, to see if he needs an attorney. Well, he's requesting an attorney, so he was previously denied. Not sure why, but at this point, I'm sure his circumstances would have changed because it sounds like he's been in custody the whole time.
So would you recommend that I speak with the prosecution?
If you're here today, you could speak with the prosecutor, because I don't know if you have anything you wanted to share that may impact, but you need to speak to the prosecutor. I didn't know if you wanted to speak to the public defender, but they don't know if they're gonna represent him at this point.
Okay, I think I'd rather speak to the defendant.
Okay, Mr. Palmer stepped out, but when he comes back, I'll let him know, okay? What do they do in the middle of an ice storm? For the bond? How does that work?
Freak out probably.
Right. How does that work?
I know when I took it, they sent out notifications. They said we're having it no matter what. Will
I
not be
think they did the
canceled
same-
For any reason.
I think they did the same thing this week, like Barxium is gonna go, it's still 2 days, right?
Yeah.
I know they switched to the UBE, but, yeah, can't imagine,
Room for him, for sure.
yeah, they'll get it this time.
I won't go far.
Mr. Easley?
Morning, Your Honor.
No, not sorry, not Easterly, Easley.
Oh.
Mr. Easley, can you hear me?
I can.
Okay, so you completed the application with the public defender. We're gonna reset your matter for March 9th, okay?
I was supposed to have a hearing the 16th of last week. I'm not sure if that was supposed to be missed or not.
Yeah, the
Correct.
hearing last week, we saw you last week, but you didn't have an attorney.
Oh, I wasn't seen last week. They said there wasn't court for.
They said it was what?
They said there wasn't court.
Yeah, the jail was moving last week, so they reset your they didn't transfer it to anybody, but you didn't have an attorney, so we couldn't proceed on your matter anyways. That's why we're having another probable cause conference today, and that's why we had you meet with Mr. Palmer, okay? We gotta see if we can get you an attorney if you're eligible to be represented by the public defender's office. And then your mom is gonna meet with Mr. Palmer in just a moment, okay?
I understand, and then we'll reconvene on the 9th of March.
On the 9th will be your next court date, sir.
So I'm supposed to stay here.
What was his bond?
Bond appears to be denied currently because I believe you missed a PCC with his own.
Back in Brian.
I think there may also be an issue. I haven't spoken to his mother yet, but I think there may also be an issue, Your Honor, because he's still quite young. The complaining witness in the matter is a family member. That's also where he resides. So I don't know that there's a valid address for him to reside at without violating the no contact order.
Gotcha. He's 18 years old.
He was born in 2004.
Mr. Easley, part of the issue here is that you were arraigned originally. Go back on the record, please. You were arraigned originally on this matter by the magistrate. She said you were not to be released without a valid address. Looks like you were released anyways, and then you failed to appear in court like you were supposed to.
I actually followed procedure, but actually my grandma was sick.
Okay, do you have a place to reside that would not be in violation of the no contact order?
I do.
Where is that?
I should provide the address on the stream.
You don't
my
have to
grandparents.
provide it. No, you don't have to provide it on the live stream.
I can approach Judge.
Okay. You may approach. Hold on a moment.
And then Mr. Palmer, the last digit of the address is the 6. To be correct.
Okay.
Yes, sir.
Okay, so you're gonna stay with your grandparents, sir?
Yes, Judge.
Okay, and you're gonna make it to all your court dates from there? Is that a
Yes,
yes?
Judge.
Ma'am, are you gonna help him make him to these court dates?
I'll make sure.
Okay,
I've-
is she a victim? Okay, you can't help him because you're a victim now.
I don't even know how long I got into the situation.
I don't either. You gotta talk to the prosecutor about that.
There-
But nonetheless, your grandparents, they're gonna be able to help you get here, sir? Your parents, your grandparents? Do you
I'm
drive?
not sure. I do not drive at the moment,
How
no,
are you gonna
ma'am.
get to Luther?
I wasn't aware of the fact that my mother was a victim.
Okay,
There was an incident
I'm
with,
happy to address the bond, but I'm concerned about how he's gonna even get there with the no contact order. His mom seems to be unclear as to how she became a victim. I know she didn't want to speak to the prosecutor before.
Yes, she is, both, she and William Easley. Who's his brother and also resides with the director. So,
Okay.
I will make sure that they will bring.
Your parents?
Yes.
Okay, sounds good. I think the original bond that was set was 2,000 personal recognizance. I'll reinstate the bond at 2,000 personal recognizance. You need to make sure your court date, sir. I guess your grandparents will have to be responsible until this situation is worked out, because your mom is listed as a named victim here, and so you're not to have contact directly or indirectly with her. Do you understand that?
yes, ma'am.
There's also a no
Right.
contact order as it relates to a William Easley, okay?
I'm not sure how I'm gonna be able to communicate with my grandparents due to the fact I don't have a mobile device or email at the moment.
Because you don't have a mobile device, correct? Is that what's
Correct.
going on? Okay,
Yes,
and you
ma'am.
need to communicate with them so that, for what purpose? For them to pick you up?
Yes.
I'm gonna order your mom to communicate that, okay? I'm the only third party who can communicate to her on your behalf, okay?
I understand.
Are you able to make that arrangement for him? Okay, your mom will make the arrangements, okay, sir?
Yes, ma'am.
Do you have any other questions while we have you here?
No, Judge.
Judge, the only other thing I would ask Mr. Easley to do is that as soon as he is released, he contacts the public defender's office. Our telephone number is available online. The issue is that because you do not have a phone number or email, there's not going to be any way for us to contact you. So we'll need you to contact us, okay?
I understand, Mr. Palmer.
Very good. Okay, we got Mr. Palmer, your grandparents' number. Do you have any questions, sir?
I do not, Judge.
Okay, you're all set. Your bond has been amended.
I'm free to leave.
You're free to go.
From this facility or? Oh, no.
Yep, you'll be free to leave from the facility. You're being released on your own personal recognizance, okay? It means I'm trusting you to follow my order and come to court.
I understand. So I should, I'm so sorry.
You're fine.
I should wait at the downtown courthouse.
You're
to
in
be,
Mason right now, sir, correct?
excuse me?
You're in Mason right now. So you're gonna be
Yes, ma'am.
released from Mason, okay?
Yes, ma'am.
And your mom's gonna contact her parents to come get you, okay?
Yes, ma'am.
Does that clarify your concern?
Yes, ma'am.
Okay. You can let the deputy know you're all set then.
Appreciate you, Judge. Thank you.
You're welcome. Okay, thank you. To a one count of use of methamphetamine under MCL 333.74042A-A. Do you understand that to be the offer extended to you, sir?
Yes, Your Honor.
Do you wish to accept that offer?
Yes, Your Honor.
Please raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Thank you. You can put your hand down. Mr. Hatton, I have an advice of rights, the information sheet. Is that your signature?
Yes, Your Honor.
Did you read this document?
Yes.
Do you have any questions about any of these rights?
No, Your Honor.
Do you understand them all?
Yes,
You understand that you have to give up all of these rights in order to accept this offer?
I do.
That means you're gonna give up your right to the presumption of innocence. So you're innocent until the prosecution can prove beyond a reasonable doubt that you're guilty. You want to give up that right?
Absolutely, Your Honor.
Okay, and you want to give up the right to have a trial. You have the right to a jury trial. You understand that?
Yes, Your Honor.
You have the right to have the prosecution bring forth evidence to prove each element of the charge beyond a reasonable doubt. You have the right to see, hear, or question any other witnesses the prosecution intends to call against you. And you have the right to call your own witnesses to trial or present evidence at trial that you believe would further defense of this charge. You're willing to give all of that up?
Yes, Your Honor.
And you're also gonna give up the right to remain silent, not have silence be used against you. You understand that as well?
I do, Your Honor.
Anybody forcing you to give up your rights today?
No, Your Honor.
Any threats being made to you in exchange for you
No.
pleading guilty? Are you on probation, parole, or on bond in another matter?
No.
Okay. You're being held in Eaton County?
Yeah, he is on bond. in
Something's
some
going
matters.
on, yeah.
I know, I'm in Eaton County, but Your Honor, I'm not on bond. Obviously, I'm being,
Okay, you have a pending matter?
yes, ma'am.
Okay, no bond in the other matters, what you mean? You don't
Not
have
that
a
I
bond?
can- Not that I can.
He does have, it appears, Your Honor, he does have some other matters pending in our jurisdiction. He has some matters 54B. It appears he was also just recently, within the last day or two, arraigned on a felony traffic matter out of 55th. It appears he may have a personal cognizance on that,
Okay.
I didn't know
according to the records.
that. I know I was,
That's not good. You probably should have a further conversation with him after this about some pending matters you have.
absolutely. Your Honor.
And his matter in Eaton County, I believe, according to Mr. Hatton, he has entered a plea on that and he is waiting to be sentenced.
Okay, you do remember that.
Yeah, I do, Your Honor.
Okay, you understand that a guilty plea could have impact on any probation or parole status that you have?
Yes, Your Honor.
Okay, you also understand that a guilty plea could have impact on any employment status, or you may have to report a conviction to your current or future employer. You understand that?
Yes, Your Honor.
You also could have an impact on travel status, like you, or immigration, like if you wanted to go to Canada. You understand that conviction could impact that, correct?
Yes, Your Honor.
Okay. Are you entering a plea today because you believe you're guilty?
Yes, Your Honor.
As to the added count two of use of methamphetamine, how do you plead?
Guilty.
Factual basis, please.
Mr. Hatton, I want to take you back to February the 10th of 2021. True, that date and time that you were at the Atlantic Police Department lockup here on Michigan Avenue.
Yes.
And that's because you've been brought in on some warrants, is that correct?
Yes.
And at that date, time, and location, in your pocket, that you have a controlled substance known as methamphetamine?
Yes.
Do you have any type of prescription or lawful authority to be in possession of that controlled substance?
No.
With an amount that would have been for your personal use?
Yes.
And did that occur here in Kingdom County?
Yes.
Satisfied, Your Honor?
Any questions from the prosecution?
People are satisfied here.
The court is also satisfied with the factual basis. I'll accept your plea. Find your plea be made freely, voluntarily, and intelligently. This matter will be set for sentencing Friday, April 21st, 2023 at 8:30 in the morning. Prior to sentencing, you need to meet with our probation department so they can prepare the court for the pre-sentence report and recommendation. I'm also ordering that you undergo a substance abuse assessment, okay?
Yes.
I didn't see them earlier, did I? No. Do you have any questions today?
No, Your Honor, it was all cleared up right now.
Oh, okay, sounds good. Any additional matters for the record today, counsel?
I have nothing further on that, Mr. Hatton, Your Honor.
Nothing from the prosecution?
Nothing from the people here. Thank you.
Thank you, you're all set, sir.
Your Honor, we're ready for a waiver on Raphael White.
Okay, we're on the record in the matter of the people of the state of Michigan versus Raphael Demikio White, file number 23-0283 FY. Appearances for the record.
Keith Watson, appearing on behalf of the people of the state of Michigan.
Thank you, Your Honor. Feel comfortable. Right, standing immediately to my right.
How are you, Mr. White?
Good, how are you doing?
I'm doing well, thank you. Today's the date set for a preliminary examination. I have a domestic violence third. And the parties are waiving, is that correct?
That's correct, Your Honor. People will unconditionally waive our right to preliminary examination. My understanding, the defendant will do the same.
That's a correct statement, Your Honor.
Is there an offer?
The offer at this point was a domestic violence first offense, and that offer will remain open at least until the initial pretrial date is certain.
Okay, Mr. White, do you understand that you have the right to have a preliminary examination during the district court? You understand the purpose of the exam? You understand that you have the right to have the prosecution put forth sufficient evidence today to establish that there's probable cause sufficient to that a crime was committed and probable cause to charge you with the crime. You understand that? You sure? You don't look sure.
Yep.
Yeah. Are you chewing gum?
Huh?
Are you chewing gum?
Oh, I'm sorry.
What's in your mouth?
I'm sorry. Yeah. Sorry about that.
Okay. Are you sick? You can keep your mask on. Okay, she has to be able to hear you. I need you to speak up. Do you understand that, the purpose of the exam?
Yes.
Okay, you want to give up that right today?
The way.
Yes.
Yes.
So you don't want to have an exam, correct? Okay, you sure?
Yes.
Okay, anybody threatening you to get you to waive the exam? You hear him?
No, Your Honor.
Okay. Any promises being made to you if you waive your exam?
No.
And you're waiving it freely and voluntarily?
Yes.
You're not sick, are you? Okay. Come get this. We'll sign it.
Thank you, Your Honor.
No problem. The bind over date's gonna be March 8th. You do not need to appear in court on March 8th, okay? That's the date the circuit court gets to file from this court, okay? Your next court date will be a pretrial in circuit court. For the prosecution, your offer will remain open until that time. You and your attorney will be made aware of what that next court date is, okay?
Okay.
Usually Big Ol' tags it up for us, but he didn't get it.
I can approach, Your Honor.
You may, thank you.
Thank you, Your Honor.
Thank you. You have any questions, sir? You understand this waiver is unconditional, so you can't change your mind when you leave here, okay? Any additional matters for the record?
Not from the defense, Your Honor.
Nothing but people, Your Honor. Thank you.
Thank you, you're all set. Good luck, sir.
Thank you. I'm very-
You too. You sick? No, we're just making sure. Let's see.
Mr. Easterly said that they requested adjourn.
I don't think he's in here. Easterly. Oh, I can't see because there's a big computer right here. Okay, we're on the record in the matter of the people of the state of Michigan versus Alon Thomas, file number 22-03546. Council appearance.
Steve Quasit, appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Robert Eastman on behalf of the defendant, Mr. Elon Thomas, who was present and standing to my right.
How are you, Mr. Thomas?
Good, and you?
I'm doing well, thank you. Let's see, today was the date that was set for a preliminary examination, and there's a request to adjourn.
Yes, Your Honor, the people are requesting to adjourn. I received an email yesterday. I think it looks like this came in indicating from Trooper Robert Delapel that he had received the subpoena but wouldn't be able to attend due to childcare conflictions. And he was apologizing for the late notice. We have a trooper here who could begin our exam. Trooper Mater is here. And I've had an opportunity, both defense and I have had an opportunity to speak with him. And so I had given the defense an opportunity to either begin the exam, and then we would ask for a continuance because there were some statements by the defendant that we would need Trooper Dale Appeal to testify to. And I believe that we're both agreed that it would be better to just go ahead and adjourn the exam rather than do it piecemeal. But I'll let Mr. Easterly make a statement.
I would agree with that, Your Honor. I think if, unless the court was inclined to not grant continuation, it's ready to go. But if the court is going to do that, we'll stipulate to
I would have granted it, but I hate continuations because it makes me have to remember this case longer than I feel is necessary.
Sure.
So I would prefer we do it all in one swoop, so we can reset it.
Thank you.
Thank you.
March 17th at 9:30. That work for council?
March 17th. That works.
March 17th at 9:30. We'll get you a new notice to appear. Any additional matters for the record?
Nothing.
Not for the rest.
We like the nice green tie. Don't. It's good color. All right, have a good one.
I'm waiting for the print.
Okay, who's next? Who? Found good cause last time.
Thank you, so Your Honor, that's just my case.
We'll have them bring up your mind then. It's already started. On the record in the matter of the people of the state of Michigan versus Grant Domain, file number 22-03178, Council Thomas.
Good morning, Your Honor. Kristen on behalf of the people. Karen Robinson, Assistant Public Defender for Mr. Domain.
Thank you. And today was the date and the time set for a preliminary examination. Are we ready to proceed?
Yes, Your Honor, the people are ready. We are ready as well.
Any preliminary matters?
I guess just too briefly, Your Honor. I guess in the interest of this meeting time, I'll announce what I'm doing ahead of time. I intend to elicit hearsay testimony from both of my two witnesses here today under MRE 1101 subsection 8, with this being an identity theft case for purposes to prove with regard to property, the ownership, authority to use, value, and possession. And also, I have a voluminous document. It basically is an offer of proof. It's bank statements and bank records. It's 296 pages that's been shared with defense. There's a particular month at issue. These bank documents go over a number of different months. I guess I would just ask if the court has a particular preference. I have parsed out the month at issue, and I have two proposed exhibits. It's the month of March. I can provide in terms of the number of pages. The defendant's bank statement would start at page 100 in that large voluminous document, and then the complainant, the complainants would start at 224. So I think in terms of relevancy, it would just make sense for me to discuss the month at issue in terms of hitting the entire document. But I'm happy to be there.
I think that your method works for me. Any objection to that?
No, Your Honor. Thank you, Your Honor. With that, I'm ready to proceed.
Okay, any preliminary matters from the defense?
We would just invoke the rule.
Proceed.
Thank you, Your Honor. People call Detective Keisha.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat, officer. Please state your first and last name, spell them both.
Peter Scacia, PeterScaccia.
Proceed, counsel.
Thank you, Your Honor. Good morning, Detective. How are you employed?
I'm a police detective with the city of Lansing,
And are you assigned to a particular unit or division?
the domestic violence unit.
And have you been assigned as the assigned detective to two separate cases involving defendant Grant Dominy?
Yes,
And was one a torture case, and then the other, the one we're here for today, is charged as an identity theft and computers case?
correct.
Who was the victim in the torture case?
Marina Lane,
And who is the victim in this case?
Marina Lane.
And through your investigation, did you come to learn Marina Lane was living at 313 Kensington, City of Lansing, County of Hingham,
Yes,
throughout the month of March?
2022.
Or 2022, thank you, okay. Now, through your investigation in both cases, are you able to identify the defendant?
Yes,
Okay, and how are you able to identify him?
I physically met him at the England County Jail.
And do you see him here today in court?
Yes,
Can you please indicate where that individual is located and also identify an article of clothing he's wearing?
he's at the end of the table that you're standing at. Blue, white t-shirt.
Your Honor, may the record reflect the witnesses identify the defendant?
Any objections?
No objection.
Identification is noted.
Thank you, Your Honor. Now, as you were in the process of investigating the torture case, did you come to learn any additional information?
Yes,
What was that?
that there was some financial transactions made from Mr. Dominguez's account, or to Mr. Dominguez's account from Marina Lane's account,
Okay, and how did you come to learn that information?
through communications through jail phone calls.
And then when you, those communications through jail phone calls, what were those communications?
Objections, hearsay?
A statement by party opponent.
Objections overruled.
So I'm sorry, you said the question.
Sure, so you mentioned some potential jail phone calls or correspondence that you listened to or read,
Yes,
and was that from the defendant?
yes.
Okay, and based upon that, what was the defendant indicating?
He wanted monies transferred from Marina Lane's account into his.
All right, and based upon that, did you take any further course of action?
I did.
And what was that?
I obtained a search warrant for the bank records of both individuals.
Okay.
Through Lake Trust Credit Union.
Through Lake Trust Credit Union, all right, and at any point outside of your investigation in the torture case, did you speak to Miss Lane about this particular case?
Yes.
And what did you learn when you spoke to Miss Lane in this particular case?
Sure, she was in the hospital at the time I got assigned, so once she was out of the hospital and able to communicate, I obtained her bank records that she provided me, and she advised that there were several charges or withdrawals that she did not approve.
All right, and did she, well, let me ask you this, how did she go about communicating that to you in particular, what she, the transactions that she did not approve?
In person?
Okay, and did she provide you with anything?
Yes, her
And-
bank statements.
Okay, so she provided you with bank statements. Was there any type of special notations on those bank statements?
I believe it said Lake Trust on the top and savings and checking accounts.
Did she make any notations herself?
She circled the fraudulent charges.
Okay, and would you recognize that document if you saw it here today in court?
Yes.
Your Honor, may I approach?
You may.
Handed you a stapled document. If you could just take a moment and flip through that.
Yes.
Is that the document that Ms. Lane provided to you with her bank statements?
Yes.
Okay, and is that the same document that she circled the fraudulent transactions?
Yes.
Can you just describe a little bit what she told you in terms of what was taken from where?
Sure, she said approximately $31,000 were taken out of her account and transferred. She identified the different dates and the different dollar amounts on these two forms from her savings and checking accounts.
Okay, so there are two specific accounts. She had a checking account and a savings account,
Yes, both through Lake Trust.
and there were fraudulent transactions in both.
Correct.
Okay, and what were the dates that she circled on that document that she did not allow for those transactions to happen?
So according to the savings account, on March 22nd, 2022, there were two charges. March 23rd, 2022, there was one charge or transaction. That's from the savings. From the checking account, March 22nd, 2022, there were two charges or two transactions. And March 28th, 2022, there was one transaction from the checking.
Okay, and the bank statement that Ms. Lane provided you, and you mentioned circled the transactions that she did not allow. Did it indicate on the statement what the transaction was?
The dollar amount?
Sure, dollar amount.
The dollar amount is identified, yes.
Can you please indicate what the dollar amounts were for each corresponding date?
Okay.
And actually, I'm sorry, let me ask you that again. I'm sorry, that was a poor question on my part. Can you please indicate, first starting off with the checking account, what dollar amount for each corresponding date?
So on the checking account, on March 22nd, there was a $7,000 withdrawal. And actually says withdraw cross member trans. On March 22nd, 2022, $4,000, and it says withdraw cross member trans. And March 28th, 2022, $5,000 withdraw cross member trans. Those are all from the checking account.
And from the checking account, does it list there what the checking account number is?
Yes, at the very top.
What is the checking account number?
10004361790.
Okay, and can you please go to the savings account and also just do the same, indicate the corresponding dollar amount for the transactions that she did not allow for and which date?
March 22nd, 2022, $5,000, says withdraw cross member trans. March 22nd, 2022, $4,000, withdraw cross member trans. And March 23rd, 2022, $6,000, withdraw cross member trans.
All right,
That's from the savings account, and I can read the account number.
yes, if you would, then for the savings account number.
It's 10004361760.
All right, and your Honor, may I approach?
You may.
All right, and then after you spoke with Miss Lane, and you indicated that you were acting of search warrant,
Correct.
and why did you author the search warrant? What were you looking for?
Well, I needed to verify that the account, the document that she provided me was her actual account. Just verified it through Lake Trust officially.
Okay, and were you able to do that?
Yes,
And was that in fact her account?
yes,
Well, and I should say it was, were both in fact her accounts, the savings and checking?
correct.
Okay, and you indicated, I believe, that you were also looking for defendant's bank statements as well?
Yes, it was also through Lake Trust Credit Union, so it was all on the same search.
Okay, and was there a point in time where you received documentation or items back from your search warrant request?
Yes.
What did you receive back?
The both accounts for Miss Lane and then Mr. Donnelly's accounts.
Okay,
History.
and throughout your investigation, what, if anything, did you learn at this point?
So the transactions that she circled on that document that I just read coincided with the official bank records from Lake Trust.
Okay, and coincided in what way?
The dates, the amounts all matched,
Matched to
both documents.
defendant's account as well as Marina Lane's account?
Yes, as well as the official Lake Trust Credit Union information letters.
Okay, and you reviewed that documentation that you received?
Yes.
And let me ask this, did you ever come to learn of a relationship or any type of, I guess I'll just ask that, any type of relationship between defendant and Marina Lane?
Yes.
What was that?
Objection, hearsay?
You want to respond to the objection?
Your Honor, it's through his investigation of what it was. It doesn't go to the truth of the matter. It's simply like how they knew each other. It's not whether or not the defendant took the money.
It's not to the truth that matters, sir. It's not being offered for that purpose, so the objection's over.
Thank you, Your Honor. What was the relationship?
They had a dating relationship and they lived together.
Okay. Your Honor, I have nothing further for this witness at this time. Thank you.
Okay, cross-examine.
Yes, Your Honor. Detective Scasia?
Scatia.
Sorry.
Whatever, I'll answer.
I'm bad with names. All right. So during your investigation, you stated that you spoke to Ms. Lane directly, correct?
Correct.
When was that?
The exact date,
Correct.
I believe the time, I'd have to look at the report on the exact date. I know I was assigned the case on March 28th, 2022, but she was incapacitated at the hospital and unable to speak at that time. So I'd have to look at the report to tell you the exact date I did talk to her.
And what report would that be? Would that be for this case or for another case?
This case.
May I approach, Your Honor? Do you recognize this document?
Yes.
Okay, go through and read that document, and if it would help you refresh your recollection on what date you spoke to Ms. Lane.
So I guess there is an incident report, 225190270. That may also have that information on there as well. It's the same, it's the original report as well.
Okay, so the report that you're looking at is not a complete and total report.
Well, it coincides with the original investigation. It says that on top.
Okay, so there's an additional report where you include information about the details with your interview with Ms. Lane.
It says this report coincides with report number that I just read. Refer to both reports for complete details.
And so that would have the information about your interview with Ms.
It would
Lane.
have the exact date on there, yes.
Thank you. Can you give me a rough estimate about how long she was in the hospital for?
Approximately a week, maybe 2.
And was that at Sparrow Hospital?
She started off at the hospital in Owasso. I'm not sure if it's the name of it, Mercy Medical maybe, and then was transferred to Sparrow. So correct.
And when you spoke to Ms. Lane, was that interview recorded?
I've spoke to her several times and I'm not sure if it was that time that we're talking about. I don't think it was.
And you are a plainclothes detective, correct? So you don't wear body worn camera?
Correct.
Okay. Did you speak to anyone else in relation to this case besides Ms. Lane?
Yes.
And who was that?
Regarding the financial portion of all this,
Yes.
I've spoken to Wade, East Davis from Lake Trust.
So a representative from Lake Trust, did you speak to anybody else in regards to this incident?
I believe I spoke to her mother.
Is that a Miss Carol Lane?
Yes,
Do you remember when you spoke to her?
it was approximately the same time frame as I spoke to Marina. About a week after getting assigned.
All right, and in the related incident, that's alleged to have occurred on March 25th, correct?
No, prior to that,
Prior to that, do you know what day?
no. It happened over several days.
Well, let me rephrase that question. So in the prior incident, was she taken to the hospital on March 25th of 2022?
Your Honor, I'm gonna have to object as to relevance. I think we're getting a little far afield. Let's see relevant.
Your Honor, I'm trying to see exactly how and when she was in the hospital and if these dates coincide with the transactions that are in the report. I'm trying to see information of how long she was in the hospital, how she was, all of that kind of information, because I think it goes to show.
Your Honor, I think it doesn't really matter if she was in the hospital. I mean, if she was in the hospital, it's more egregious. But in terms of the defendant using her personal identifying information to get into her bank account and take her money, whether or not she's in the hospital isn't an element.
Yeah, I don't know how her being in the hospital or her location at all has any bearing on identity theft. So the objection is sustained.
Thank you, Your Honor.
Did you ever become aware that Mr. Domini and Ms. Lane shared a phone?
Yes, they share the same phone.
And did you ever, through your investigation, come to find out who that phone belonged to?
The actual physical owner?
Correct.
No.
Were you aware that Mr. Domini and Ms. Lane were living together at the time?
Yes.
And were you aware that they were running a business together?
No.
When you spoke to Ms. Lane about these transactions, was there anyone else present for the interview?
No. I believe her mom drove us to where we met, but she's not there.
Nothing further.
Any redirect?
Your Honor, I have no further redirect for this witness, and I just have one further witness to call.
Okay, maybe excuse detective. Thank you.
Maybe stay in the courtroom.
Yes.
Thank you, Your Honor. Yeah, Your Honor, the people call Wade Jones and Detective Skeesh is gonna go get him from the hallway.
You can stand right here and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Thank you. You can have a seat there. There's a microphone that's in front of you, and directly behind you is my court reporter. She has to take down everything being stated in the courtroom today. So all of your responses must be loud and clear. They must be verbal. You can't do head nods, head shakes, mhm, and uh-huhs, okay? If you don't understand or can't hear the question, you can ask for it to be repeated. And then if there is an objection from any of the attorneys, you would stop responding. I'll make a ruling on the objection, and then I'll tell you if you can give that answer or not, okay?
Okay.
Please state your first and last name, spell them both.
Wade Jones, WadeJones.
Thank you, counsel. You can proceed.
Thank you, Your Honor. Mr. Jones, how are you employed?
I'm a fraud loss investigator at the Trust Credit Union.
And what goes into your particular job position? What do you do?
We I prevent fraud and mitigate our losses.
Okay, and do you investigate any particular suspicious transactions that goes on at your credit union?
Yes.
How do you do that?
Really depends on the situation.
Sure, that's fair.
It's really gray.
Sure, that's totally fair. So
Okay.
I'll ask some more pointed questions.
Okay.
Was there a point in time where you received a search warrant from Detective Scatia from the Lansing Police Department?
Yes.
And were you the individual to, I guess for lack of a better word, execute that search warrant?
Yes.
Okay. And did you provide documentation to Detective Scatia
Yes.
regarding that search warrant?
Sure.
What did you do personally when you got that search warrant?
So with the search warrants that we get, so let me start over. So the search warrant that I got, we give to our account resolution department. They pull certain documents, and then I pull certain documents as well.
Okay, what did you do specifically?
I provided the statements. That's what I provided.
Okay, and were you asked to provide banks, well, actually, I guess say credit union statements,
Yes.
bank-related statements for a Grant Domini
Yes.
and a Marina Lane?
Correct.
Okay, how do you go about identifying or locating a particular member's statement or account, so to speak?
So we have a system that we use to pull up member statements. We just stick in their member number and then go to the statements that were asked for.
How do you determine someone's member number?
By pulling them up in the system that we use daily called DNA.
Okay, and how do you pull someone up?
I enter in, you can enter in your name, your social security number, member number, phone number, address. There's many different ways to do it.
Okay, so is there, well, let me ask this, for members, do members have to provide an identification when they open an account?
Like a.
Any type of form of an identification?
Yes,
Okay, and is that standard
yes,
for every account?
yes,
All right, and did you, so you pulled the bank account statements or the credit union account statements for both a Grant Domini and a Marina Lane?
correct.
And it was a rather voluminous document. If I were to indicate approximately almost 300 pages, 296 pages, does that sound about right? Okay, and would you recognize a portion of the documents that you pulled if you saw them here today in court? Okay. And just indicating for the record, actually, Does the court mind if I mark the exhibits, or does the court wish to mark the exhibits? May I approach? Actually, I think it's 1, 2, 3. Okay, so, sir, I'm gonna approach with what's been marked as people's proposed exhibit number 1. This is just a 1-page piece of paper. If you could just look at it briefly for me. Would that have been part of the documentation that you pulled for the search warrant on the detective case you gave to you?
Yeah,
Okay, and what is that?
it's a member statement.
And our member, well, let me ask this. Are member statements standard for every member that has an account?
Yes.
Are they generated at a particular time?
I believe it's like the 31st or it's somewhere around the end of the month or the first of the month. I don't exactly know the exact date.
Okay, maybe poor question on my part. Is it fair to say that there's monthly statements?
Yes,
Okay, and that's standard?
yes,
Okay. And are those account statements kept in the ordinary course of business at Lake Trust?
yes.
Okay. And with that particular document, whose statement is that for?
Current domain.
All right, and what is the particular month and year of that statement?
March 2022.
And is that a fair and accurate depiction of the account statement? Nothing's been changed?
Correct.
Your Honor, people move to admit people's proposed exhibit number 1 into evidence.
Any objection?
No objection.
Equals 1 is a minute.
Thank you. May I approach?
You may.
And you also indicated that you pulled account information, account statements for Morena Lane as well?
Yes.
Okay, and Your Honor may approach with people's proposed exhibit 2.
You may.
And sir, I've handed you a stapled document. If you could just briefly look at each page. Okay, and what did I hand you?
A statement.
And is that essentially the same form that the people's admitted exhibit 1 was?
That's correct.
Okay, fair and accurate depiction of that statement?
Mhm.
Has it been
Yes.
changed?
No,
Kept in the ordinary course of business at Lake Trust?
correct.
Okay, and is that of Morena Lanes?
Correct.
Okay, and what was the month and year?
March 2022.
Your Honor, the people move to admit people's proposed exhibit 2 into evidence.
Any objection?
No objection.
Equal 2 is a minute.
Thank you. May I approach?
You may.
Thank you. All right, Mr. Jones, did you also, well, let me ask you this, part of your job, do you take case notes?
Yes.
And what was the investigation or your part in this particular, I guess I should say investigation from your end at Lake Trust?
So I like from start to finish. Or
Very fair question. So after Detective Scatia contacted you and after you became involved, what was kind of the first thing you did?
so the first thing I did was review both member accounts. And based on the information provided by Detective Scatia, the activity seemed suspicious. At that point, I locked the accounts down. And investigation.
Okay, and was there a point in time where you spoke with the account holder, Miss Lane?
Yes.
Okay, and what, if anything, did she indicate to you about the account transactions?
I verified, well, I asked her about the cross-member transfers, and she said that they were not authorized. She did not authorize those transfers.
She did not authorize those transfers?
Correct.
What are cross-member transfers?
Just a transfer between one member account to another member's account.
Okay, and this may sound like a very dumb question, but how is that done?
Through online banking.
Through online banking? Okay, and could you just describe a little bit more what online banking means? Does that mean through a computer, a phone? What does that
It
mean?
could be a phone, it could be a computer.
Okay.
Yeah, phone or computer.
Okay, and what did you determine upon your investigation and pulling these records and reviewing things for Detective Scatia, but also in your capacity too as investigator at your credit union?
So when reviewing the transfers, they were done at the time that Detective Scatia said that she was.
Well, actually, I gotta stop you there because that would actually was called hearsay. So with
Okay.
that, what you determined though, based upon talking to Morena Lane and based upon your review of both accounts, of both defendant's account and Morena Lane's account, what did you discover?
That the transfers that were done were unauthorized.
What were the transfers done?
The several thousands of dollars worth of transfers.
Okay,
I'd have to see the actual list. I don't know the
sure,
numbers.
absolutely. May I approach Your Honor with People's Minute Exhibit 1 and 2?
Yes.
And these account statements that we just talked about a little while ago of both Morena Lane and defendant, do those indicate the cross-member transactions that Ms. Lane did not authorize?
Yes.
Okay, and were the only cross-member transactions that she did not authorize direct deposits into Mr. Dominique's account?
Can you repeat that?
Absolutely. So the cross-member transactions that she did not authorize,
Correct.
were those all to Mr. Dominique's account?
Yeah.
Okay. And just a couple more questions, Mr. Jones. In regard to the dates, and if you don't remember, it's perfectly okay. I can show your report if you need me to. Do you recall the specific dates where those cross-member transactions occurred between defendant and Ms. Lane's account?
Not the exact date. I know there were a few.
Okay, would looking at a copy of your case notes jog your memory as to dates and also dollar amounts?
Yeah.
Can you approach her? Just handed you a 2-page document. This was, I believe, titled your SAR report, and it's just, I'm looking at page 2. If you could just look at that, read it to yourself, and once your memory's been refreshed, please look up. Okay, what dates and also dollar amounts?
So there's 4 on March 22nd, 2022, for 7,000, 4,000, 5,000, and 4,000.
And those are from Ms. Lane's account to Mr. Downey's account, defendant? Okay, and then what were the other ones?
There was one from March 23rd, 2022 for 6,000, and March 28th, 2022 for 5,000.
And I asked you this a little bit, but I'm just gonna ask a follow-up question. Any indication that any of these were done in person?
No.
How would they would have been done?
Through internet banking.
Through internet banking?
Yeah.
All right. Your Honor, may I approach?
Right,
Also, Your Honor, may I publish People's 1 and 2 to the court?
please.
I have nothing further this time, Your Honor. Thank you.
Cross-exam.
Mr. Jones, correct? Mr. Jones, so you stated that you personally pulled these records for both Ms. Lane and Mr. Dominique,
I pulled some of them, yes.
the ones that you relied on here in court today?
Yeah, yes.
Now, in those records, you stated all those transfers were online banking, correct?
Correct.
And with those transactions, does it say if a specific user logged in or,
Yes, it does.
okay, and what user was that?
Mariana. Is that how you pronounce it?
Now, in order to access someone's online banking account, I'm guessing they probably have to input a username and a password, correct?
Correct.
Okay. Is there anything else that sometimes has to be done in order for someone to prove identity or to gain access to an account?
They may send like a one-time password type of code to just verify who the person is logged into.
Do you have, like, is there a specific name to that? Is it called something in particular?
It might be called an OTP code.
Okay. And is that what your organization would call it?
Yes.
What is multi-factor authentication?
I don't know.
With the OTP or the one-time passcode, that would require somebody to have access to the email registered on file.
Possibly.
Are there other ways that one could get another one-time passcode?
Yes.
Okay, what are the other ways that one could get a one-time passcode?
To their phone.
When someone opens an account with your institution, do they have to indicate at the time if anybody else is authorized to use such account?
There would be certain documents that someone would have to sign to have somebody.
Okay, so there's specific procedures
Yes.
on how to do that. And are you aware of what those procedures are?
I am not.
Okay. Do they typically involve some sort of paperwork at least? Okay, and would that paperwork be kept on file with your organization?
Yes.
You did not investigate any sort of user agreement or authorized user agreement for this case, did you?
No.
Do you know if anyone else in your organization did?
No.
You stated that you spoke to Ms. Lane personally about the transactions in her account, correct?
Yes.
And then you also spoke to Detective Scasia, correct?
Yes.
All right, did you speak to anybody else in relation to your investigation? Now I know sometimes different banks or financial institutions have a policy to record conversations on phone lines. Does your organization do that?
Yes.
Okay. Do you know if the conversation between you and Ms. Lane was recorded?
That one. No.
You say that one. So was there more than one conversation with Ms. Lane?
No.
Nothing further.
Can you redirect?
Very briefly, Your Honor, if you may, Mr. Jones, what does OLB stand for?
Online banking.
Okay, and did Ms. Lane indicate anything to you about whether or not defendant had access to her account? And if you don't recall,
I would have to see my notes.
okay, that's fine. Your Honor, may I approach, looking at your notes, refresh your memory?
Yes.
May I approach Your Honor briefly? You may. Thank you. And I'm handing you your report reviewed for SAR meets requirements. Just first page, if you could just read that silently to yourself and once you remember, refresh, look up. Has your memory been refreshed?
Yes.
Okay, what, if anything, did Ms. Lane indicate to you about the OLB, the online banking, whether or not defendant had access?
She stated that he did have access to that along with her.
Okay, so,
She said what? That he had what?
The online banking access along with her.
Oh,
okay, so he had access to her, I guess, well, you tell me, what would he have access to in order to get on the online banking? Would that be her login and password?
Yes.
Okay. Your Honor, I have nothing further for this witness. Thank you.
okay, maybe excuse, sir, thank you. Will you be calling any additional witnesses?
No, Your Honor, the people refs. Thank you.
Okay, is the defense calling any witnesses today?
We are not, Your Honor.
We can proceed to argument.
Thank you, Your Honor. I'll keep my argument pretty brief. The people move for bind over as charged. The court heard from 2 witnesses today, and I'll just speak specifically as to venue. There is a specific venue statute actually that goes directly to identity theft. It's MCL 762.10C. There's a number of different subsections that establish venue, one being the jurisdiction in which the victim resides. The court received testimony from Detective Scatia that the victim did live at a 313 Kensington address during the month in question, March of 2022, which would make venue appropriate for this particular case. And in regard to the exhibits that the court received and the testimony that the court received, I would just reserve any further argument for rebuttal. Thank you.
Okay, can you give it MCL again for the venue?
Yes, Your Honor, absolutely. It's MCL 762.10C as in cat.
Okay, and these were the only 2 offers of proof, correct?
Along with the testimony, correct?
Okay, sounds good. Ms. Robinson.
Yes, Your Honor. I would just ask that you consider all of the evidence that's been brought forward today in this case. It seems to rely heavily on hearsay testimony from Ms. Lane, who is not present here today. There hasn't been much information except going into what she told Detective Scasia and Mr. Jones. But further, there's also information that shows that they were living together at the time and had purchased a house. So I would just ask that you take that into consideration when reaching your verdict.
I don't have any evidence before the court that they had purchased a house. So I can't consider that.
Well, the fact that they were living together, Your Honor.
Okay, thank you. Any re-argument?
Does the court wish to hear or offer an argument?
Yes.
Absolutely, Your Honor. So in terms of the testimony received, Detective Scasia indicated that, and of course, the testimony was received under MRE 1101 subsection 8, that the victim in this case, Marina Lane, who was also the victim of the torture case, and through his investigation, he came to learn of those fraudulent transactions on her account. She indicated that those were transactions that she did not make. There were the 2 separate accounts, the checking account and the savings account. Detective Scasia also indicated after he executed that search warrant with Lake Trust Credit Union, he received that documentation back of both account for Marina Lane victim, both checking and savings, as well as account for a defendant who also had an account at that same location, and that the dates and the amounts matched up. So there was a withdrawal from victim's account and then into defendant's account. The dates were all there. They all matched up. The dollar amounts matched up as well. Wade Jones also indicated where People's Exhibit 1 and 2 were admitted through, that those 2 account statements for the month of March, that being of Marina Lane's as well as defendants, same thing, matches up. The dollar amounts match up. The dates match up to where Marina Lane specifically said that she did not authorize those particular withdrawals from her account. There was a particular point in time where she was in the hospital, but of course, I didn't get into that because it's not an element of the particular, crime. And with that, Your Honor, with the computers count, Wade Jones testified that these were not done in person, they were internet banking. He also testified that the defendant had that Marina Lane indicated to him that defendant had access to her phone and her, or excuse me, not phone, access to her online banking information. And that would suffice under the statute, under the identity theft statute. So with that, Your Honor, I would just respectfully move for buying over. I believe the people have met the standards based upon a probable cause. Thank you.
Your Honor, can I say something, please?
You cannot. You have an attorney. You need a moment to counsel your client.
Yes, thank you.
Okay, I'll give you that moment.
We are, Your Honor. Thank you.
Okay, did you need to go back on the record for anything, Ms. Robinson?
No, Your Honor. Thank you.
Today was the date set for preliminary examination, not trial. And at the time of preliminary examination, the purpose is for the prosecution to meet their burden, which is to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you. So probable cause is a pretty low burden. It's more than just mere suspicion that a crime was committed, but not nearly as much evidence that would need to be proven by the prosecution if this matter were to make it to a trial. At trial, it's beyond a reasonable doubt. But this is a relatively low burden, and it's based on evidence presented today at the hearing. It could be based on circumstantial evidence. It could be based on hearsay that's admissible. But that information is to be measured by the court, and I'm going to be the sole determiner of credibility for the purposes of determining whether or not there is probable cause today. So what I have here was the testimony for both of First Detective Pete Scatia, and he testified about an investigation relative to, I believe, another pending matter that involved a torture case, same victim, and defendant Mr. Devine, who he identified having spoken to him personally at the jail, but he came across information during that investigation